Hi everyone, how are you? I hope you're all doing well. Yes, I normally don't show my face, but today I decided to. Hope you like it. I've got my whole outfit coordinated. My boots are on 32, so we can go straight into episode 33. Hopefully, I won't need to use my broom gavel to point out the bullshit because I like to keep her shiny for my rides around the area. There was a little touch of snow today, which I love riding my broom around in the snow, but we've made it to episode 33, which will be our final piece to catch us up to exactly where the case is. That, yes, these motions were filed in July and they are unfinished business as I showed you in the last episode in the Register of Actions, that there is nothing else that has been filed, that we have everything. We went over everything. And these are the matters at hand that were supposed to be addressed in that meeting of the attorneys face to face for the first time that I attended. And I know that I get criticism because I focused more on what the attorneys were wearing. But it was important because if I would have told you that, yeah, they came in, they were sent out to a conference room, and the other attorney said she needed time to get caught up, and they were going to talk again in 6 weeks, and that's it. That would have been the summation of the entire thing. So I decided to set the stage to really show what's going on because there is a dynamic battle in between the black and white that there is. If I were just to have read the judge's dissent and said parties conferred and agreed to come together in 6 weeks to set an adequate timeline, that's all that there would have been. But I wanted to really show you everything that's going on behind the scenes, that when there was phone calls going unanswered from one side or both and to the courthouse, it wasn't quite because of all of the incompetency that is Wright County. It is because they were, in fact, moving from the old turn of the century courthouse that was in another city over to the brand new multi-million dollar courthouse with the new jail, the new sheriff's department, the new DMV, community health offices, etc., etc. Very beautiful and new complex. So in so doing, they were switching over all those computers, which they were switching over phones and everything. So things did get lost. And in that, as I explained, there was not only a big change of scenery, literally, but also figuratively, in that we got rid of the old broken derelict judge who had made some very concerning mistakes that led to, in my opinion, and some others, led to the loss of lives in a very tragic incident that I will speak on at some point, and other issues that were very concerning. The prosecutor in place was not doing his job. He was afraid to do anything because he was to a point where he was tired of losing, essentially. And the act of actually getting any charges from the sheriff's department to the prosecutor's office that they didn't lose, that they decided that they would actually have enough evidence to go ahead and file. Then the pandemic was hitting and everything else, and so everything was by Zoom. And if people didn't show up for court, they weren't issuing arrest warrants because of COVID. So we had all of those moving pieces. Plus, we have a very, very laid back judicial system here. And again, there was confusion in how this was filed. This is a defamation case brought in civil court. They've only filed civil charges. Okay, there's no criminal charges listed. Now, when we get into the topic of sanctions, those are in a civil court financial primarily, but you can get in trouble in contempt, and then you're looking at more serious sanctions. Is like when mommy grounds you. Okay, you're in trouble. You're being reprimanded. A lot of moving pieces, a lot of backstory. In that, we may be in a position where a 50-year-old woman like me, no, a 50-year-old, 50, what, two, almost 52-year-old law that has been in place where many people have used to shield themselves. In Cervantes, Time magazine, showing that standard of protection for journalists, and then the old colloquial, I can't say the word right now, colloquial term of journalistic privilege. That's something you see in movies, and they're like, oh, okay, let's move on. So, you know, who watches too much TV? We know that she does, but apparently she's watched a movie or two, and she thinks that she's going to get diplomatic privilege or journalistic privilege or whatever kind of privilege she wants, but she's no privileged. She's not a privileged person. She's not anything other than a person who's made a lot of mistakes, who goes on basic petty gossip and uses it as gospel. And if any of us were held to the most egregious statements of somebody who was trying to bring us down, who would any of us be? She wants you to be judged by that. And that was my overall point in putting up what I had believed was her DUI. Because I didn't think that many people knew about her DUI. I only believed it to be true because I had seen and knew that she had spoken about it in ways in which she was teasing that people will never find it, blah, 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 blah. Whereas when I looked, I thought that that was hers. Now, that being said, if that wasn't her DUI, none of those parking tickets are hers either. The birthday doesn't add up to any of those things. So the fodder out there, though, that's not hers, but she has a lot of parking tickets. No. No, she doesn't. If you go by her birth date, there's not any of those things. So she must work hard on making sure that she's not held to the same unfair judgment that she subjects everybody else to, acting as if she is indeed higher than, or that she indeed does hold some type of privilege, whether it's journalistic or otherwise. But it's time to knock her down a few steps and show that, you know what? You've made mistakes too. You're not perfect. And how dare you go after strangers who are against medicating their children, that actually engage in their children, no matter what religion they are, no matter how they teach what they want to as it pertains to the afterlife. She goes after women who are actively engaging in every aspect of their home. They are homemakers. They are wives. Whether or not they are plural wives is beside the point at this moment. They are women and mothers engaged in their children's activities. They can feel their children's lives pulsing through their bodies. They are that engaged and connected with their children. And as such, they are instilling a belief system that may or may not be the same as any or all of ours, but nonetheless, it's a belief system, and that means that they are talking to their children about what is right and what is wrong. Katie Joy cannot even do that basic human, survival. Species basically teach their offspring what is right and what is wrong, what is going to keep you alive or threaten your life. Now, maybe it's only because I'm Italian, but if I were acting the way that she is, I'd be afraid that someone was going to come and whack me. I'd be afraid that I was going to get whacked. You just don't do this to people. You just don't do this to strangers. The things that she says are only the things that would come out as a excited utterance out of somebody who's deeply embroiled in a domestic relationship with somebody for several years, and thus that their relationship is so entwined and complex that the very part of their own being is being peeled away by what the other person did. So they say things that are low. They say things that are below the belt. They say things that they would never normally say. And those get put into print and put somewhere into something that you can access via Pacer. And she goes and finds that and runs as that, saying that's her source. Well, I can show something pretty funny, and I just may one of these days, that if I were to say that I read this, or this is my source, meaning that I saw it in a court document, that thus it must be true, and go and run with it and start a whole dialogue around it, it would be pretty funny. But if I dare do anything, then, I'm judged for that. I better wait till somebody is ready for something funny, okay? Because in this, it seems like there is a lot of, not only the people who are pro Katie or that hate Katie, Caters, but there are people within the anti-Katie society that pick on and eat the young within that, as any women do in a community or complex in which one woman might earn her status as higher because of something that she has done or the work that she has put in. So you get these other women who are jealous and petty and greedy. And so what do they do to get taller? They step on the necks of other women to get taller, because that's the way that they learned how to do it when they were in junior high, and they never matured past that. And I don't care. I mean, if they are people who didn't grow up, that is none of my concern. They want to bite my tail. They want to step on my neck and make sure that I'm here in exile, and that anybody who likes me is some kind of weirdo, and whatever the current narrative is because I actually know what I'm talking about, and I'm proving that. And so the dialogue must be that I do not know what I'm talking about, that I am stupid, that I am incompetent, and that I am wrong. And that what I am doing is not correct. Let's put that in caps, N-O-T, and let's put W-R-O-N-G in the comments here. And let's just keep doing that. Because that's helping what? All I did was try to impart some truth and put some explanation into what is truly going on here. And I have been made to feel like, I don't know what I'm doing, and I blah, 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 blah. So I have went through here with everything, with a fine-tooth comb for what is going on in 7M. And to be continually chastised that, I didn't do something right, or I did something wrong when somebody catches some little thing. Remember, I don't make any money here. I'm not the one who's grifting for Griftmas, okay? As I said, my channel made 22 or 24 this month? Was it 40? Did I hit 40 the month before? So now it's going to take me 3 months to even hit $100. So if you consider the time that I put in, like go and procure the documents, get them, sort them so that it's easier to narrate and break down, and take the time away from my household, which means I have to make sure everything else is all done before I can take a moment. And then if somebody needs me, I do stop and put my time in. I'm not making the kind of money that you see the people who are calling me out saying that I'm stupid and blah, blah, blah are making. So when somebody wants to sit there and point the finger at me, you might want to consider how much money they're making and why it is important that that dialogue that they are pushing against me is important. And if you are a person like me who cares more about the truth and doesn't care to make money on imparting the truth into a situation, no matter what it is, then you will understand. And you will understand and be thankful that you are a part of the solution and not a part of the problem long term. So I thank all of you who have stood by me since day one. Since day one, you know that I was in here baptized by fire, and I've had haters all the way. So each subject that I carry, I get more and more haters, and then they carry over and they keep some scraps from somebody else. So then the second that they see somebody saying something negative, they're going to glob onto them and be like, oh my gosh, yes, you know this. And yeah, she doesn't know what she's talking about. And she says things that aren't true. And well, yeah, she says things and they can't be proven and everything. No matter if I've came through with the strongest receipts, as the young people call them, as anybody. It doesn't matter. The dialogue must be that I don't know what I'm talking about so that the other people continue to make the money that they do. And that's fine. If greed is more important to them than doing the right thing, there's no way that I could ever make a difference. And so while I'm here and I'm not seeing any of the whole shitstorm, shit cloud that is following all of this, that each time before there's a hearing and before I even stepped into this, I was so confused as to what's going on because I thought that there were so many different lawsuits open. I thought that, I thought she'd gotten even in a lawsuit with Cardi B. If you go back and listen to what I did a live with, I think it was on with Snow, and we touched on the Katie Joy topic, and I was not ready to come forward and say that I actually am essentially her neighbor, that because I didn't know at first. When I first came on, the creators who are in the algorithm the most came up, and I didn't know. I was just subbing to them all and everything, and I think I had Molly and Dolly and Katie Joy and everybody that just there, just listening to everybody and getting it into a style and seeing who was who in this zoo. And then I was like, wait a minute, what no, I can't be any part of this. Oh, I'm sorry. No. And I just kind of unsubbed and walked away and be like, I can't be a part of this. No, thank you. No, don't want to be associated with that. Nope, not my time. Nope. Not my circus, not my monkeys. Or however that goes. So, I had no idea Katie Joy was my neighbor. As I saw that there was a pretty strong anti-Katie movement, I didn't even understand that WOACB was her. I had no idea. I really didn't. So then when I started looking into it, and I did that, I found, obviously, I live here and everything, and she said something about where she lived and whatever, and I think somebody had doxed her, and I was like, holy shit. I was literally almost her neighbor. We had a contract for a house to be built the block down, so in the same block. So I would have been, like maybe 5 or 7 houses down from her. KJ, if you're listening, remember that cul-de-sac that had the model home that had the everything black and white? I don't know if you went in there, but I just loved that. I loved the whole concept of the black and white house, and I wanted to do that and do bright red accents. But I couldn't get that model home. Didn't quite have enough, bedrooms, things like that, So no matter what I talked the kids into, that they could just have one room with bunk beds and everything, and, they told me to fuck off. And anyway, so essentially then, okay, they could make the same home with more bedrooms over across the street and down. And there was this beautiful little lake and this eagle's nest and all this stuff. It's a very, very beautiful area. Her area is in the original home. So to have gotten a home in that original area when all of the nature was just still beautiful would have just been an amazing way for somebody who takes their kid out for walks and fishing and everything. It would have been a great place to have to raise a child if you were actively into doing such things. So anywho, the house fell through because they forgot to essentially put one of the bedrooms in that was in the new plan, and it was just becoming increasingly hard for me to walk upstairs because of my cardiac issues and stuff. So the way the stairs were too and everything, it was just a mess. So we got our earnest money back and backed out of the deal. And nonetheless, as the year has went on, and I started looking into her a little bit, I realized that we do have more things in common than one would think. And so then I really was buying into that whole narrative and everything and thinking that, my God, she's going to go to jail and prison and they're taking our kid away. I'm like, my God, our CPS is broken. It doesn't do anything. So what the hell did they prove here? Because honestly, our CPS is just, don't get me started. Don't get me started right now. Some of you who may remember me from all the way back to Lady Justice may recall when I touched on the subject of our CPS. Anyway, someday I'll tell those stories again, but not right now. So I just believed that there was this big, like I say, this big, huge big shitstorm coming. So then with oh yeah, well, Katie Joy's getting ready for this, blah, 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 blah. And I'm like, oh my God, what's going to happen? And like I told you all, I literally went to my courthouse the week before the hearing and said, look, that'll be a big thing. You're going to need extra security, extra deputies. You're going to have so many people here that you need to be prepared. Let's be standing room only here. And they're like, for what? And I told them, and they look it up and they're like, well, I don't see that there's anything out of the ordinary. And I'm like, all right, don't listen to me. Lo and behold, I was the only one that showed up. So when they're looking at me the next week, put me through the metal detector, and I'm like, so a lot of people aren't here for that. And it became glaringly obvious that I was the only person there for that, because there was a hearing for somebody who, well, I better just shut up. So anyway, it was apparent by my attire that I did not fit in with the person who was bringing all of their family members for a hearing. So that's where, I looked and I grabbed some stuff and said, hey, look, I'm going to get everything all caught up so we know where we're at with this. Because I just did the basics that I would have for any case that I was briefing, like in school. Got a couple memorandums and whatnot, thought that would catch me up. And then I was like, what? What are they referring to? What is this? How is this? What? And I went back to the Register of Actions and I'm like, holy mother of, are you kidding me? And then just started going through and printed it all off, and they had to bring more paper over to the printer. They're looking at me like, what are you doing? And I'm like, I'm getting the stuff on the Katie Joy. And they're like, what? So got it all and was still just so confused and overwhelmed and everything looking at it. And I am a very visual person, as you guys can see, and I have to break things down into little tiny nuggets. And some of you have my same learning style, and that's why we are bonding. It is a different learning style, very visual. If I write it down in black ink and stuff, my brain sees that and then I keep it. So if it's not written down in black ink or highlighted, chances of you being able to read it, number one, is low. But for me to remember it are low. So as I went through, broke this all down, and saw that, in fact, this is the only open case. And this is where we're at with it. And this is what is going on. And that this was indeed filed in civil court. And then explained the way that our CPS office works. That if they cannot confirm that the allegations of abuse have happened within 24 hours, that is closed out and it's done. And they play a little game of, because we are so rural, most of the towns and townships out here do not have a police department, so there is no community policing. It is only sheriffs. And if you understand the difference between a police department and a sheriff's department, you understand maybe a little bit more about how difficult it is to expect that there's going to be charges, because there's not enough dollars for prevention and the community awareness. Oftentimes for CPS involvement, it takes that CPS officer who understands the vibe of the community and the family and the reputation of the families and what they're seeing and what's going on. They're sheriffs and they have different ways of doing things. So when you do get a report, then CPS will say, well, we're going to leave it into the hands of the sheriff. And if the sheriff sees something that we need to do something about, then we will act. Okay? So then you think, well, they've already reported the crime, blah, 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 already the issues are there. Well, no, there's no reason that the sheriff's going there. So then you have to re-report. And then when the sheriff can get to the lower priority, because they've got serious things going on, not to say that child abuse is not serious, but when they have literally loss of life in an intersection somewhere or in a home, they are attending to that. And they put a complaint about possible child maltreatment to a lower priority call. So then they need to go there. If they don't see anything at that moment or anything where that child is in imminent danger, then they're going to say that they didn't see anything worthy of bringing charges or filing charges. And they will also stand behind what is going on in the home and the parenting style. So although I may not agree with somebody's parenting style, it is not my right to say so, nor theirs as how they see it. So although they might walk into a situation where there are some very difficult emotional and verbal things going on and physical abuse is reported, they will say that that is within the parent's right. It's very difficult. And then they will say, well, we'll leave this in the hands of CPS. If they choose to act, then we'll enforce it. And it goes back and forth like that. And then that 24 hours has went, and what you reported has not been substantiated, and it's done. So any of that in that shit cloud where people thought that, well, yeah, they reported this and that, and as long as they have a doctor's note saying that that child needs that care, none of our opinions matter. A good mother who's actively engaged in her child, medically complex or otherwise, is going to do every single thing in their power to make sure that their child has the optimal ability to survive and thrive in this life, especially in the absence of them. A good mother teaches independence. A good mother teaches survival. A bad mother is one that teaches dependence and does not optimize the child's overall potential for lifetime success, medically complex or otherwise. From day one, we have to assume that we may not be there in the next hour or tomorrow, and that we have to be able to transition knowing that we taught our children how to do the best they could with whatever capacity, even if they're just learning how to breastfeed or drink from a bottle. It's being engaged with your child and showing them you eat, sleep, and poop. And then when we get those three things going, then we go into other things, okay? We're going to just do the basics. But you teach about danger, and you do so by talking to your children and in interacting with your children. And dare I say that if you are a person who wrote an article bitching about straws and that restaurants are not carrying straws, and you show that straws are an integral part of your child's life, and that, in fact, metal straws are a hazard, that reusable straws are unsafe. Dare I say that if that child is strong enough to suck from a straw, that child has enough oral skills to learn with consistent therapeutical intervention, engagement, and patience to learn to eat enough that one would not need extra support such as that of a feeding tube. Well, how do I know that? Because I've had 3 premature babies and 1 baby with cerebral palsy. Okay? So, 3 babies that came out with sensory integration disorder from their premature births that didn't have the ability to drink from a straw, blow a bubble, etc., etc. So they were in PT, OT, and speech 3 times a week until they were 3. Maintenance throughout, and my child with cerebral palsy needed it throughout. And there's still touch-ups, and he's 20. My husband, their father, has been incredibly patient in that when he would have to work all day, be a provider, so that we would have medical benefits for those interventions and medically complex medical needs, and the doctors at the Children's Hospital and whatnot, and the co-pays for all of the therapy that we had to pay for, were there, that he would come home to me being a sick wife and 3 kids that needed special diets, and he accommodated and made us all different dinners before he fed himself. That's a man. That's a father. That's a husband who's engaged with his children. And I'm so grateful. He says he wouldn't have known to do that if it wouldn't have been for me, that I taught by example. And I appreciate that, but I also give him the credit. That a lot of dads would have been too tired. And in days gone by, the dads would have been at happy hour and came home, and that's what it takes. And if we needed to sit down and stay at the table or have 5 small meals for the children instead of 3 and replicate what they learned in therapy, we did that. I mean, my child with cerebral palsy, brushing his teeth was something that was never going to be able to happen because of all of the sensory integration. We had to work hard to even be able to brush the child's teeth. But he has beautiful teeth and doesn't have any cavities and everything because we had to work for that. So being able to get him to be able to suck from a straw, blow bubbles, eat textures, different tastes and whatnot. He doesn't like what we like. He likes some weird food because of the way that his body works, because he can't feel half of his taste buds. That's part of the frustration from other mothers like me with medically complex children, in seeing that we work to find solutions to optimize our children's potentials. And when you have somebody like her who gets all of the attention in those groups, but doesn't want a solution, she's not solution-based, then that's where there's concerns. And that's where a lot of the reports have came in, from what I understand. But now giving you this 30 minutes of kind of background information as to the global aspect of what we are dealing with in our place in the world. And I don't know that there's a CPS in the country that is functional. But ours is especially not. And they are not going to take away a child because the people on the internet don't think he needs a feeding tube. As long as a doctor thinks that he does, and the doctor obviously is allowing that feeding tube, she's fine and she knows it. And she'll go with that twatty attitude that don't bring him into the picture. He's not, but she uses him as a vice anytime she wants to. But if you're bullying her, you're bullying the mom of an autistic, medically complex child. Don't think that you would find anywhere on here where I would say, you're bullying the mother of a child with cerebral palsy. Have I said that? I'll wait. I just saw this clip, and I'm going to put it on my community page of her daring to say that her child takes more trazodone than her and still doesn't sleep. What in the actual... Okay. Yes. My child, too, was prescribed trazodone, as was I long ago. So I could probably go in my closet and show you full bottles of trazodone that were unused. I gave my child 1/4 of a pill once. He did not like the way that it was. I did not like trazodone. I don't take any sleeping meds, as you guys know. You know, when I needed them, Ambien. And I certainly didn't like trazodone for the way that it makes you feel very much sloth-like. And for me, it made me have nightmares. So her saying that is really concerning. The other concern is that with a lot of drugs in that paradigm, less is more. So the more you give, you can get like an opposite reaction. Kind of like melatonin. And a lot of people are, oh, you can take melatonin, it's natural, nothing will happen, blah, blah, blah. Yes, there are things that can happen from melatonin, and I do not support giving melatonin to a child. And I know I'm going to get a bunch of things like that, but you know what? There's a lot of things where it's like, you know what? You need to find other solutions. So if you are a person who gives melatonin, understand that a lot of times less is more with that. Because I'll have people say, oh, yeah, they put their kids with 15 milligrams of melatonin and they still wouldn't sleep and everything. I'm like, what? You mean 15? What are you talking about? Yeah, how many? What? No. That was supposed to be 1.5. Start with 1.5. Well, they don't do 1.5. That was 15. No. That means you take half of a 3 milligram. And you start with that half of the 3 milligram. You're more likely to get a better result with 1.5 than you are with 3, with 5, with 7, with 8, 15. I'm not kidding you. So, with that again, remember, the narrative is that I'm stupid and I don't know what I'm talking about, and I am wrong, and I do not know what I'm talking about. So with that, let's proceed here to that little last sprint and get to the end of episode 33. Now, this one, my friends, is written by attorney Jennifer Moore. Okay, and this is dated that July 25. So, this is her last stated order, as I showed you in the register of everything, actions and everything. There's nothing more I can see. Now, does that mean that I haven't been to the courthouse in, a week or whatever? Has something been filed since then? Maybe. So I honestly can't say that because then, somebody's going to come with that and be like, look at Tabitha Jane's wrong again. Wrong all the time. Doesn't matter. I can't even believe she remembers to breathe in and out at this point. Lord, can't. And I couldn't even believe it on the Reddit thread that people said that they can't even understand what I say. I mumble. Well, here's episode 33. Anywho. I've never been accused of mumbling in all my life. Oh my God. Okay. Once again, that's it. Episode 33 comes with this reply memorandum supporting defendants' second motion to compel. In this case, type civil in the County of Wright with the 7M Films Incorporated, Robert Shin, Miranda Derrick, and James Derrick as our plaintiffs. Versus Catherine Mansky Paulson, a.k.a. Katie Joy, and Without a Crystal Ball, LLC, as the defendants. The introduction states, plaintiff's motion to defendant's second motion to compel misstates the burden of persuasion with respect to motion to compel. It ignores the substantive content of the defendant's motion outlining the efforts made to narrow the issues for the court. It also ignores the fact, starting a sentence with the word it. I've never gotten away with it. Oh my God. It also ignores the fact that plaintiffs have failed in their own obligations to secure their rights under the rules. Okay, now let's see here. Burden of persuasion, substantiation. So, we can glean here that there may have been something in a telephone hearing or in the information that we cannot see that's under protective custody, a protective order, where the judge may have said you need to narrow the scope of this complaint. So sometimes when you read something, you kind of need to branch out and say, okay, where did this generate from? Plaintiff's response to defendant's second motion to compel is wholly consistent with an intention to prevent defendants from defending a lawsuit that was likely brought as a strategic message to prevent others from negatively reporting upon them. It is certainly not consistent with foundational precedent that provides that mutual knowledge of all of the relevant facts gathered by both parties is essential to proper litigation. Okay, and that is citing from Jepson versus Swanson, 243 in Minnesota, 547, 551, 68 at Northwest 2D, blah, blah, blah. Quoting Hickman versus Taylor, so she cites some of this case law. Okay. Moreover, I like sentences that start with moreover. There you go. I'll take away that little mark and give you a little gold star there. Moreover, plaintiffs have failed to set forth a substantive response to defendants' request to amend the protective order, probably because to do so, plaintiffs would need to explain to the court why it believes that any party is advantaged by a protective order that contains structural barriers to enforcement of its rights thereunder. I don't like the usage of it's there. I'm going to put there. But anyway, argument. Plaintiffs have the burden of persuasion to establish that objections to discovery are proper. It is well-settled law that a party seeking to limit discovery must establish grounds for not providing the discovery that are specific and factual. The party cannot meet its burden by making conclusory allegations. In Hill versus Auto Owner, blah, 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 case law, burn, blah. Okay. The party objecting to the production of information has the burden of establishing that the sought-after information is immune from discovery. However, plaintiffs turn this well-settled burden of persuasion upside down by telling the court that its defendant's obligation to say why plaintiffs' objection are not valid. Okay. Plaintiffs appear to believe that the language of Minnesota Rules of General Practice in 115.05 somehow shifts the burden onto defendants. That rule provides that for motions involving discovery requests, the moving party's memorandum shall set forth only the particular discovery requests and the response or objection thereto which are the subject of the motion, and a concise recitation of why the response or objection is improper. Okay. In a case such as this, the concise statement is not meant to shift the burden of proof. It is meant to permit the court to examine each discovery request in an organized way. That has a footnote of 1. I'm going to read that footnote so this reads better. Footnote states, that defendants note that plaintiff's memorandum supporting its motion to compel fails to comply with this rule in that it did not set forth defendants' responses. Okay. That rule also provides that memoranda and reply memoranda may not exceed 35 pages except by leave of court. The rule is premised on the belief that by the time a matter reaches the court, the parties should have made some effort to communicate such that they have a basic understanding of the other's arguments. But it does not shift the burden of persuasion onto the moving party. Okay. All right. I get it. But in the same right, it is my opinion that the reason why the issues are not more concise is because Katie Joy hides behind whatever privilege she acts like she has to. I mean, she goes by all privilege except for white. Plaintiff's allocation of the burden of persuasion would place the defendants in an impossible situation. Defendants do not know what information is in plaintiff's possession. Thus, it would be impossible for defendants to formulate a response to an objection that the discovery sought is unduly broad or overly burdensome in proportion to the needs of the case. And plaintiffs have not helped the court by providing any factual basis for its objections. Okay. Plaintiff's allocation of the burden of persuasion. This is just a bunch of lawyer speak. In presenting defendants' defense to plaintiff's motion to compel, counsel describes the efforts she made to locate the statements that plaintiffs claimed to be defamatory. Counsel explained that some statements that plaintiffs alleged to be defamatory were never made. Others may be contained in social media posts referenced in the complaint with links that are no longer valid. Oh my God, not this again. Counsel further explained that it is difficult to identify sources and a factual basis for statements without a specific citation. That's where she wasn't saying in court. This is exactly the sort of detail that would support a court's order limiting discovery. Plaintiffs have provided no explanation at all why their objections are valid, though. Okay. This is nicely shaped up language by the firm for when Jennifer Moore said, well, I don't know, because the Instagram, they delete things and they're no longer there, and so we can't find them, and my client is a person who posts up to several times a day, and it's impossible to, well, not impossible, but to keep up with that. Okay, I'm paraphrasing. Moreover, even though it's plaintiff's burden to establish that it is appropriate to limit discovery, defendants undertook a detailed analysis of the discovery sought and the objections asserted by plaintiffs as to each interrogatory and request to produce documents which form the basis of defendants' motion to compel. For example, defendants explained that plaintiffs' response to interrogatory number 9, seeking information about guilty pleas to criminal offenses, was inadequate. Defendants are baffled by this response. It would appear that one or more of the plaintiffs have been convicted or pled guilty to a criminal offense. Otherwise, the appropriate response to the interrogatory would have been easy. Apparently, plaintiffs expect defendants to engage in a 50-state search of court records to locate information that plaintiffs have in their possession. That is an absurd interpretation of the rules of civil procedure. This information is not sought to embarrass the plaintiffs, but rather to determine where there is a criminal conviction that could be used to impair their credibility as a witness. Okay. Defendant's motion of supplemental second motion to compel at 10. This analysis fully addresses plaintiff's objection that the information is publicly available, not relevant, and sought to harass and embarrass parties. Okay. They're objecting that that was her intention. It is my opinion that is completely her intention, and that is how she plays her game. Plaintiffs also ignore the fact that by ignoring their obligation to timely object to discovery, they have waived the right to object except on the basis of privilege, work product, and experts' conclusions. And that's for the Private Bank of Minnesota versus Anderson, number blah, 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 and unpublished in Nexus, extending the holding of Garrity versus Kemper Motor Sales, cases arising under the current rule. Thus, the court need not undertake the effort to examine any of plaintiffs' objections except for privilege, work product, or experts' conclusion. Okay, now we're going to go here. Stating that the third item of consideration is that plaintiffs failed to respond to efforts to narrow the issues for this motion. The counsel must admit that plaintiffs' argument that defendants failed to certify that they attempted to meet and confer inspired some amount of outrage. What? What? Counsel must admit, so that would be Jennifer Moore, is saying that 7M's argument that their client failed to certify that they attempted to meet and confer inspired some amount of outrage. I think that Graham was popping off quite honestly, but they are not in a position to be this cocky. They have a client who needs to be reined in. Okay? I'm just going to say it. And if I get bashed for it, it's my opinion that an attorney doing their work would tell Katie Joy that this is very serious, that she stands to lose everything that she's built her life upon. That the time is now to stop this pattern of behavior. That if indeed she wants to be called a journalist, that she needs to act like a journalist and earn that title and privilege. And maybe they have. And maybe she just completely ignores them. I don't know. The other thing I was considering is that because some of these issues are criminogenic in nature, if you say that you have knowledge of a person being waterboarded, or you have knowledge that somebody is engaging in human trafficking, those are crimes. So if you are telling your attorney that you are aware of crimes being committed, an attorney cannot hide behind attorney-client privilege and say, well, yeah, she told me that these crimes are going on. It would be that attorney's duty to report knowledge of criminal ongoings to the effect that you would the attorney would say, where is there proof of this happening? Because we need to file a police report with your information. And that would go a long way in showing that there is substantive proof in what she's saying in at least one of those counts. And then they would be able to say that, yes, we discussed it and it was proper to make the move to identify the local authorities. We did so, and we said that this person noticed this on this date, and they came to Katie Joy, and Katie Joy is passing on that information. As such, we are reporting by duty that failure to report would be negligent, problematic, or otherwise. You can't ignore the seriousness of these claims. And maybe that's all been done. But you'd think that then, if there was any proof of it, then police reports would be shown, and anybody can say anybody's doing anything. It was still, and so even if there's a police report, it warrants an investigation, and the person that said it to be talked to, and their credibility to be evaluated, and to see if it rises to the level of the prosecutor filing charges. The fact that that is not there speaks volumes. A lot of times when you're looking in this, you need to think about how that was generated, that this is the offshoot of what rooted plant. All right, back to the script. Okay. Minnesota Rules of Civil Procedure, page 37.02, does require the parties to set forth the efforts undertaken to resolve discovery issues. Counsel's declaration supporting defendants' motion to compel indicates that she attempted to secure plaintiffs' participation in narrowing these discovery issues in letters dated March 27, 2023, April 28, 2023, and June 12, 2023. Okay. So we have these dates, and those are attached to counsel's declaration supporting defendants' motion to compel indicates that she attempted to secure plaintiffs' participation in narrowing these okay. Plaintiffs did not respond to these letters until sometime after 11 p.m. on July 10th, the day before briefing on these motions were due. Okay. Okay. So they're saying that Amber didn't respond until the last moment. Defendants' submissions further outlined the fact that plaintiffs did not attempt to engage in discussions as to defendants' discovery responses until July 7th, 2023. Okay. Despite these extremely tardy response, despite this extremely tardy response, defendants were able to adjust its arguments in half-prepared briefing to reflect the arguments and supplemental discovery made by the plaintiffs therein. What? Well, this is the same attorney that said that she was on vacation and the 4th of July happened and that she couldn't possibly have done anything. So, how dare her, who was begging for mercy to get caught up, call out the other side? All right. Perhaps plaintiffs believe that the rule requires some magic language rather than a substantive discussion of the efforts defendants made to resolve oh my God. Whoa. Okay. Perhaps plaintiffs believe that the rule requires some magic language rather than a substantive discussion of the efforts defendants made to resolve discovery disputes. It does not. Whoa. Oh, man. Slap your grandma. Moreover, even if the rule did require a formal certification, the remedy for the failure to secure such a certification would be to adjourn the proceedings to require the parties to make additional efforts to resolve the discovery disputes. Defendants submit that would be inappropriate in this case. Plaintiffs have failed to be persuaded by the arguments made in connection with these filings and have made no effort to clarify the basis for their objections or to offer additional discovery. Oh my God. Big talker here. Big talker. I see why Jennifer Moore was in civil, because she can talk some words. The terms of the protective order permit amendment. Plaintiff's only response to defendants' request to amend the protective order is that defendants have not cited any authority permitting such an amendment. Paragraph 9 of the order provides that any party may apply to the court for a modification of the protective order. Order at 3 February 7, 2023. Clearly, defendants are entitled to seek amendment of the protective order, and the protective order should be amended based upon the fact that plaintiffs have designated every shred of paper as confidential, and the time and effort to object to each designation under the terms of the existing order are not consistent with the just, speedy, and inexpensive determination of every action. Minnesota Rules of Civil Procedure 1. Bam. I'm telling you. Jennifer Moore can talk here. I don't know. Strong language there. I think Graham and Jennifer were pecking at the keyboard for this one. For the reasons stated herein, the court should issue an order compelling plaintiffs to answer discovery and amending the protective order to permit a challenge to a confidentiality designation to be made and presented to the court at such a time as it becomes necessary to assert such challenges. Respectfully submitted, Troutman Martin Law, and signed and signature as Jennifer Moore. Boom! We are done! Yes! Yes! Thank God! We are here! All right. I was just finishing up. You guys who are local, or you know what? There's other states that have it too. You guys have, know what I'm talking about when I say Hy-Vee, the grocery store that's Hy-Vee. Where I'm from, we have really good grocery stores. Well, where I'm from, we have Rose Hours and Safeway, Albertsons, and stuff like that. And we really don't have that anywhere else per se. When I lived in California, there was more like Ralph's and stuff. Not really. I mean, I found some good deals at Ralph's. In Vegas, groceries were just ridiculous. It was much cheaper just to go to the buffet as a local. And that was actually great with the kids and their special needs for foods, because then they could just go to a buffet and they have everything they need, and they loved it. And as odd as it was, the kids loved themselves some broccoli. They loved steamed broccoli. So here we are trying to find everything we can and, accommodate. And then it's the broccoli they loved. They could not get enough broccoli, steamed broccoli and whatever. And so they were like 3 and 4, I think, in that time frame when we were in Vegas. And so when I wasn't in the hospital, I would take them to the casinos during the day and walk around so they could see all the art and everything. And so when we moved out here, we went to like an Easter buffet or something. And my kids were like, what? My daughter was like, how am I supposed to eat strawberries without the chocolate fountain? Like she had never seen strawberries on a buffet without a chocolate fountain. That's raising your kids in Vegas. Oh, our favorite buffet as a local in Vegas would have been the Silverton. The Silverton is off the strip a little bit, and it is where it's attached to the Bass Pro Shop, which I really liked because I'm a person who likes to walk it off after a buffet. So it was, go to the Silverton buffet and then walk the kids all through the Bass Pro Shop afterwards, and it's pretty nice. And even when I was in a wheelchair and whatnot, it was wheelchair friendly. But so anyway, Hy-Vee. Hy-Vee is a grocery store that I love out here. It's a little pricey, so you kind of have to watch their prices. I mean, their weekly sales are good, but they have a lot of good apple ciders or ciders for the season, and they're in these juice. I think it's their brand or close to their brand. It's not very expensive, but anyway, I was just drinking this spiced cranberry cider. It's really good. It's warm. It's good warmed up with cream. I know that sounds weird, but it is. It's good that way. And so I was drinking that. What else is good at Hy-Vee this time of year? That's where I get a lot of my teas too. So yeah, thanks for another episode, the final episode, and then I'll just be able to do maintenance, and hopefully I'll be able to change my schedule around and be able to go to this hearing. If not, then I'll go to the courthouse a few days after it and get all of the information like this, and then we'll just do maintenance here and add as it goes. And if they settle out at any point, we'll know, and we'll know where this one went. And it is official. I am going to narrate the entire Michael Todd Chrisley series. It is juicy. When I was making my binder and putting the papers in and peeking at some of the stuff that went down, whoa. I think that the Chrisleys are still both in prison. So I have all of that. And I have another one too. Debating on if I'm going to read all of that. That one's interesting as well. And I might do the Tati one too. Who knows? But I am going to take the time to update where we are at with the local case of the unaliving of Madeline Kingsbury by her domestic partner, Adam Fravel, as he unalived her during a domestic assault, which enhances that charge. And he's also charged with the problems with the way that he disposed of her body. So I have that. I'm going to update that, and that's also in a playlist. So, and I'll be attending that trial. I hope I'll be able to do that. And I do have the stuff about Shankella Robinson. So if you guys haven't heard that one yet, that's also in a playlist. There's not too much going on in that. Our government is still going back and forth with the Mexican government trying to get things, but I did narrate Shankella's autopsy and whatnot. Shankella is the one who went down to Mexico with a group of who she thought were friends and they turned out to not be her friends at all, and in fact did end her life by, it seems that they kicked her in the head. They were going to, Mexico was going to do special charges to charge it specifically as a crime against a woman, because the genders of the people she was traveling with were different than hers at birth. And so the nature of the assault was not necessarily woman to woman in the way that she was brutally kicked, beaten, otherwise assaulted. It was a kick from a freaking man. And I'm sorry, but when you read her autopsy and see what she went through and that there hasn't been justice, it's really sad. So there's playlist on Shankella, Madeline Kingsbury. You know, I went down deep with the Watts. There's always the Michelle shit show. And I need to find out what she's doing. And not that I care, because I've been clean of Michelle for how long now. But I'm sure that she'll be coming up as the Grinch that stole Christmas anytime soon. It's just so nice that that channel that was going on nightly and screeching and screaming about her every freaking night was stopped from doing that, because that's settled down the Michelle shit show. So there's Michelle videos. I narrated the Unabomber's manifesto after the Unabomber had passed away recently. I narrated the correspondence with Barry Lukatis, who was one of the only surviving school shooters, and he is from my hometown, and this was a school shooting that was very near to my heart, and I knew the people involved, and so to kind of have some insight on who Barry is, and to kind of see that we need to find out the genesis and why school shootings are happening, because what's going on at home can lead to something terrible at school. Barry was in a position where he thought that he had nothing to lose, as his mother told him that she was going to go with her pew-pew and unalive herself in front of his father and his new girlfriend. So Barry was under the impression that he was going to be orphaned within a couple of days anyway. So he took that pew-pew to school and killed his teacher. And so there's that there. There's the Casey Anthony letters to her cellmate, so you can kind of get some ideas of where Casey Anthony's headspace was before the trial. My dear friend, who was Native, who was in MMIW, her murderer remains in prison for something different that I ended up getting him put back in on a parole violation, as he did not and never has been charged with her murder. And that's something that I would hope that you all would make time to listen to. That's the story of Jessica Alva. There's a lot of stuff. Like I say, 467. So this is 468. There's 468 videos. So if you guys are ever like bored or want something to do, well, or listen to while you're cleaning the shower, taking a shit, who knows? I mean, I've been told that I'm great for all of those things. So thanks for listening, and I will talk to you all soon. I hope you're having a great weekend. And for Veterans Day, I would like to do a shout out to all of the veterans and the spouses of veterans, because Lord knows they're doing the hard work. So thank you for your service to the veterans, and to the veterans that have spouses who have held them up and held the home down while they're away. Thank you for your service as well. And on my community page, I put up a link for veterans suicidal. It's a link that as of, I think it was May 2023, any veteran anywhere can go to any emergency room at the VA or otherwise and tell them that they are having a mental health crisis, and all services are free. That it does not matter if they have insurance, if they are connected with the VA or anything, or if they, had a discharge other than honorable, etc., etc. It does not matter. If they served in the military and they're having a mental health crisis, they do not need to worry about paying for services. That is a free treatment option at any ER in the United States. Okay. And it just to support that as well. So that link is on my community page. I think it's a couple of posts down. But there is also the Veterans Crisis Line. And the website for that is www.veteranscrisisline.net. And you can do an online chat as a veteran. And you can text 838-255, or you can call 1-800-273-8255, extension 1, or by TTY, you can do 1-800-799-4889. And again, thank you to the veterans. Thank you for your service. And if you need any type of help, if you're in a crisis, that is a free option to go to the emergency room. If you need that number emailed to you, let me know. My email, as you all know, is tabithajane0@gmail.com. Not the word zero, but the actual number 0. So tabithajane0. It's not an O. @gmail.com. And thank you for listening. Thank you. Bye-bye.